NACDL is the association of the nation's criminal defense bar.
We are going to take a little bit of time here to talk to you about how we arrived at Carpenter, what happened in Carpenter, and particularly roads forward. I think the three of us are in pretty solid agreement that though the court went out of its way to talk about the narrowness of its holding, the reasoning is potentially broad and may have implications across any number of areas of cases that you will be litigating on behalf of your clients. So we're hoping to have a little bit of a conversational back and forth, but generally I'm going to start talking about the history of how we arrived at the Carpenter litigation itself. Nate, as the foremost expert on this, is going to talk about what happened at the Supreme Court and in the Carpenter case. And Judge Smith is going to talk a little bit about the related litigation and also ways forward, and I think we'll all chime in at that point. So, as you all may know, Carpenter deals with kind of a set of Fourth Amendment doctrines and issues. The key one at issue in most of the discussion that the court had was the Third-Party Doctrine. So as a refresher, if you haven't looked at the Third-Party Doctrine in a little while, it started around United States versus Miller, which was a case decided in 1976. The Supreme Court said that a person has no reasonable expectation of privacy in bank records. That was what was specifically at issue in Mr. Miller's case. The specific records were canceled checks, deposit slips, account statements, things like that. The court said that those papers were not Mr. Miller's papers. They were, in fact, the bank's records. And relying on previous precedent about individuals sharing information with police informants or co-defendants who had flipped, the court said, you don't have a reasonable expectation of privacy in that information you disclose to other people. You're essentially making it not private and thus not covered by the Fourth Amendment when you share it with someone else. In United States versus Miller, that was extended to cover documents, records, and later data. So fast forward 2 years to Smith v. Maryland, which is the companion case, which was about phone records. It was a pen register case about whether there was a reasonable expectation of privacy in the phone numbers dialed. Similar to Miller, the court basically said there's no reasonable expectation of privacy here because you provide those digits for the phone number to the phone company. And the court also went into great detail about the fact that people know they're doing that. They're willingly sharing information with the phone company to route their call. As a result, and there's a legitimate business purpose in the phone company retaining those records, right? They have to bill you for a long distance call or a local call. And as a result, those are really the phone company's records. They're not yours. You don't have a privacy interest in those records. For decades, the third-party doctrine was broadly interpreted to mean any type of information you had shared with a third party was not covered by the Fourth Amendment. There were some restrictions kind of several decades on from these cases. For example, in Ferguson v. City of Charleston, the Supreme Court held that there was a reasonable expectation of privacy in diagnostic test results that were in the custody of the hospital that had run those tests, right? That's kind of one of the earlier chips away at this very broad interpretation of the third-party doctrine where anything that someone else holds is fair game. In 2010, and this is another case that I think is important to a lot of your practices, the Sixth Circuit held that the Fourth Amendment protected the contents of email communications. So not necessarily the to from line, but what's actually in an email. So this is another thing where that information is held by a third party, but the Sixth Circuit said, still protected by the Fourth Amendment. You have a reasonable expectation of privacy in that information. You have to get a warrant before you go to, for example, Gmail to get the contents of someone's inbox. The reason I think it's important you all know this is even though it's only a Sixth Circuit case, it's effectively the law of the land at this point. There are no appellate courts that have disagreed, and my understanding is that the providers themselves understand this to be the way the Fourth Amendment operates, and so they don't disclose the contents of email communications absent a warrant. So that's kind of one body of cases that were at issue in Carpenter. The second is this kind of question about whether or not digital is somehow different than the death by 10,000 cuts that Judge Menendez just mentioned at the Fourth Amendment. So talking about the case of Cairo v. United States, which is a 2001 Supreme Court case, the court held that there is a reasonable expectation of privacy in thermal signatures emanating from the inside of a house, right? So this is not about data held by a third party, but it is about using technological means to gain access to information that law enforcement otherwise wouldn't be able to get kind of in normal physical, like the normal physical world without a warrant. They wouldn't be able to get information about the inside of your home without getting a warrant first. So the court relied on the idea both that you would normally need a warrant to see what's going on inside a house, and the idea that the technology at issue wasn't broadly available or used by the public. It was kind of contained to mostly law enforcement, right? In 2012, in United States v. Jones, a case I'm sure most of you have read and are pretty familiar with, the court held that the government needed a warrant to attach a GPS tracking device to the bumper of a Jeep. The GPS device was going to track the location of this Jeep 24 hours a day over the course of more than a month, or almost a month. There was a 5-justice majority that said that that physical intrusion, the act of attaching the GPS device to the bumper, was a search. That is what ultimately the case turned on. However, there was a 5-justice shadow majority, is how it's sometimes referred to, that indicated that the invasiveness and amalgamation of the information that was gathered could also constitute a search. That case is basically what led directly to Nate's work on Carpenter. And so before I turn it over to him to talk a little bit more about that, I want to just point out that throughout all of these more recent technology-related cases, courts were wrestling with these two lines of cases and how they fit together. How the third-party doctrine applied to digital data held by third companies, right? This is a technology case, sort of, but it's also a third-party doctrine case, sort of. For example, to tell you just how long and difficult this struggle back and forth was, Judge Smith issued the first opinion on cell phone location tracking in 2005. So judges were dealing with it at least that early and trying to consider how these two things fit together. But it wasn't until this past summer in 2018 that the Supreme Court gave more definitive guidance on how they fit together. I think Nate has quite a bit to say about that.
Thanks, Megan. And thanks to all of you. I'm really thrilled to be here, both to speak to you all who are doing this crucial work every day on the front lines, and also to be in the company of a number of people who have been working on this issue for well over a decade. Judge Smith, who issued an opinion that predicted the ultimate outcome in the Supreme Court 8 years ago. Catherine Crump, who was litigating these issues at the ACLU before I was, folks from EFF, and of course, dozens of defense attorneys, hundreds of defense attorneys across the country, bringing suppression motions while the law of the third-party doctrine looked like it was really terrible for years to try to build up the case law that got us to where we are today. So I'm really happy to be talking to you. In some ways, I feel like this is the most useful way I can spend my time now, because you are the ones that have to spot the issues going forward to leverage Carpenter in related situations. The cases are going to come out of your client situations. I sit at my desk all day and think big Fourth Amendment thoughts, but without your work, there's no point in that at all. So thank you. Whatever one thinks about the wisdom of the third-party doctrine 4 decades ago in the 1970s in those pre-digital contexts, it just has not held up well in the digital age, when it's virtually impossible to go about our daily lives as a modern human being without leaving these trails of digital breadcrumbs behind us that are stored not on our own computers, not in our houses, but on the servers of dozens, maybe hundreds of companies that we have some persistent or fleeting relationship with. And the kinds of data that now reside on other companies, other entities' servers are tremendously diverse and voluminous. The Carpenter case itself, of course, is about cell site location information. How many of you here have had cases involving historical cell site location records? So a significant majority. So we know from transparency reports from the cell phone companies that there are well over 100,000 requests for historical cell site location records per year, at least leading up to Carpenter, to the 4 major providers. It's a tremendously powerful type of evidence for the prosecution and for law enforcement because it can corroborate other types of less reliable evidence, placing a person at a particular point at a particular time. So as all of you who have had these cases know, just very briefly, every time you use your cell phone to make a call, receive a call, send or receive a text message, make a data connection, the phone company logs a record of which cell tower your phone was talking to and which directional antenna of that tower, called a sector. Most towers have 3 directional antennas, some have 6. And over time, those location records can really chart out a quite detailed picture of someone's life as they're moving about through space and time because, of course, we carry our cell phones with us virtually everywhere we go throughout the day. They sit by our beds when we're sleeping. They're in our pockets or our handbags, no matter where we go. And even when a phone is sitting in your pocket, it may be making data connections or receiving text messages in the background that result in these location records being generated. For years, the mechanism that the investigators used to get cell site location records was the Stored Communications Act. That's a statute passed in 1986. In 1986, about 1/3 of 1% of Americans had cell phones. There are about 1,000 cell towers in the whole country. There are well more than 300,000 of the big cell towers you see on top of buildings or on street sides today, and millions of so-called small cells that can be installed, inside buildings. Congress manifestly was not thinking about cell phone location records, but they created this statute that was amended in part in the early 90s that created 2 mechanisms to get at non-content records held by electronic communication service providers. So in other words, contents other than, information other than the contents of the communications themselves. One was an option to get a search warrant under Rule 41 or a state analog. And the other was to get a court order on what's essentially a reasonable suspicion standard, well short of probable cause. It's a word soup, but most courts have said it's somewhere between relevance and something higher, certainly lower than probable cause. Not a warrant, doesn't require a sworn affidavit, doesn't require particularity, relatively easy to get a magistrate judge to sign off on compared to a warrant. This is what happened in Mr. Carpenter's case. It was an investigation in the Detroit area of a series of robberies, ironically, of cell phone stores, of T-Mobile stores, and Radio Shacks, where Mr. Carpenter was eventually charged with being part of a kind of rotating crew of guys who was ripping off these stores and then reselling smartphones on the black market. Local police in Detroit, before it turned into a federal investigation, arrested a few people they thought were involved in this ring. One of them quickly flipped, gave the names and phone numbers of people he said were also involved. Timothy Carpenter's name and phone number were among there. It then became a federal investigation, and AUSA went and got one of these orders under the Stored Communications Act, 2703D orders, from a federal magistrate judge in the Eastern District of Michigan, asking Metro PCS, the phone provider, for 152 days, about 5 months worth of historical cell phone location records for Mr. Carpenter. Within that 5-month span were a series of those robberies that were being investigated. The provider sent back about 4 months of records, 127 days. It turned out that the account had terminated before the last month, so they didn't have everything. And an FBI agent went through this, and lo and behold, it placed Mr. Carpenter right at or near the scenes of several of those robberies, 4 of them at the times of the robberies. And this became key evidence when the case eventually went to trial. All the other evidence, virtually all the other evidence on the prosecution side was testimony of alleged co-conspirators who had all flipped and taken plea agreements and were subject to impeachment. That was the main defense strategy. But these records are seen by juries as extraordinarily objective, right? Corroborating every one of the accounts of those co-defendants. The defense counsel brought a suppression motion. It was denied on third-party doctrine grounds by the district court and by the Sixth Circuit. And then we had been involved as amicus in the Sixth Circuit and then co-counseled to bring the case up to the Supreme Court, where the court issued this really landmark opinion in what is styled as a 5-4 decision, but I'll explain why it's really kind of more of a 6-3 decision for important reasons. And a decision that, as Megan said, while Chief Justice Roberts said a number of times, it's a narrow decision, the reasoning, I think, is just going to be absolutely vital and central to how we interpret the Fourth Amendment going forward in all kinds of digital search and seizure contexts. And so let me spend a few minutes talking about what the court actually decided, and then a few more minutes talking about how we might extract some good language and tests and lessons maybe from this decision about one type of records to go forward in all the other situations that you and your clients may be facing. So the court had to decide really three distinct but interlinked issues in this case. So first, is there a reasonable expectation of privacy? Is there a privacy interest in these records about location over time? Second, even if they express something that we think is constitutionally significant and private, does that matter because of the third-party doctrine? In other words, does the mere fact that they're held by this company just erase whatever privacy interest you might otherwise think you have? And then third, even assuming there is in fact an enforceable, reasonable expectation of privacy, is it the kind of expectation, is this the kind of search that requires a warrant, or is a subpoena or some kind of similar compulsory process like this court order on a lower standard sufficient? And the government made very forceful arguments on all three of those, and the court rejected all of them. So the court explained first why this, at least longer term, historical cell phone location data is so private, and so private that it rises to a constitutional level of protection. So it talked about the prolonged nature of the location tracking and everything you can tell about a person's life from knowing where they've been over a long period. Not only that they were at the scene of a crime, but when they go to the doctor, the political rally, the meeting, the psychologist's office, etc. About the historical nature of the data in the sense that it's essentially a time machine effect, this retrospective compendium of data that gives the government the power to decide today they want to call up a perfect summary of everywhere a person has been 7 months ago, when even that person themselves probably couldn't have remembered it in any detail remotely approaching this. Talked about how it reveals a quote, intimate window into a person's life. It's near perfect surveillance, as if the government had attached an ankle monitor to a person. And the court also talked about trends in technology and borrowing some language from the Cairo case, the thermal imaging case. The court explained that even if the prosecution was right here, that the relative precision of cell phone location data in 2010 and 2011, when the investigation in this case happened, wasn't so great, that it was, knowing which cell tower and sector you were in just gave you maybe a half-mile to 4 miles square mile area. It's not like placing some person in a bedroom. They really belabored this at all stages of the case. The court said, even if that's true, we have to take account not only of the state of technology under the facts of this case several years ago, but the state of technology today and the trend in technology going forward. And it's absolutely clear that more cell towers are going up all the time, meaning they're closer together, meaning the area that they cover is smaller, so you can more precisely locate people. Cell companies are better able to triangulate location, even in historical data. Cell companies are installing these so-called small cells that might serve an individual house or a doctor's office if they don't have good cell coverage. It's getting more precise, it's more voluminous, people are using their phones more. We have to set a rule that protects us going forward, not just one that's relevant for this one case that happened to have arisen 7 years ago. And then, really critically, and I think this is maybe the most important language in the case to address types of data and types of searches that may appear at first glance to have nothing in common with cell site location information, is that the court repeated language that had initially appeared in Cairo, the thermal imaging case, and again in Jones, the GPS case, explaining that one of the core purposes of the Fourth Amendment in these kinds of digital search cases is to assure preservation of that degree of privacy against the government that existed when the Fourth Amendment was adopted. What does that mean? It basically calls on the court and on advocates to figure out what is new about this technological capability in the sense that what does this give the government the power to do something that prior to the digital age, it literally never could have done, right? So in this case, it would have been just literally impossible before the cell phone age for the government to decide today, as I said, to pull up a perfect listing of everywhere I had gone 2 years ago, 5 years ago, 6 months ago. These records are retained by the cell companies for quite a long time. It changes the balance of power between the populace and the police in a way that requires some protection under the Fourth Amendment. And that kind of categorically new view of what the search is doing is important. It's not just a change in degree, it's a change in kind, and one that we need to protect against. So having explained why this stuff is private and sensitive and the Fourth Amendment has a role, the court then had to address whether Smith and Miller, the third-party doctrine cases, just cut off the debate anyway because, in fact, these aren't your records. They're the company's business records. And the court did not overrule Smith and Miller very explicitly. We didn't ask them to, as a matter of very careful strategic thinking, not wanting to ask them to bite off more than they could chew in this case. But the court declined to extend Smith and Miller to what it called these novel circumstances. And it did so in part by looking at language in those cases themselves that was used to explain why bank records and dial telephone numbers weren't so private or sensitive anyway. So it looked to the nature of the records, which both Smith and Miller talked about, right? In those cases it said, well, from a pen register you only know what phone numbers are dialed, not the contents of communications, not even how long the call lasted, not even whether it connected. In Miller, the court talked about how these were transactional records, negotiable instruments, you're passing them into the stream of commerce, lots of people have to see them, including the bank. And here the court said there's a world of difference between the limited types of personal information addressed in those cases and the exhaustive chronicle of location information casually collected today. And the court also looked at voluntariness. Key to those earlier 1970s cases was this conception that you're voluntarily and knowingly giving the phone number you dial to the phone company, passing that check back to the bank so it can draw on your account. Here, however, cell phone location information, as the court said, is not truly shared as one normally understands that term. And that's for two reasons. One, because, as the court explained, carrying a phone is indispensable to participation in modern society. You can't reasonably be expected to leave your phone at home all the time when you need it for professional life and family life and social life and emergencies and so much more. And second, once you're carrying that phone, it logs cell location information by dint of its very operation without any affirmative act on the part of the user beyond powering up. So this is just different. It's not something that the court could have contemplated 4 decades ago. And so the court explained, and this is the language kind of towards the end that I think where Justice Roberts tried to encapsulate all the sweeping language and great descriptors he'd used before. He said that in light of the deeply revealing nature of the CSLI, its depth, breadth, and comprehensive reach, and the inescapable and automatic nature of its collection, the fact that such information is gathered by a third party does not make it any less deserving of Fourth Amendment protection. So now we know the Fourth Amendment has a role here. This is a search. Does that mean a warrant is required? The court said yes, and this part of the opinion is the part that has received the least attention in kind of popular commentary, but I think it's equally important. The government made a really concerted argument, and Justice Alito in his dissent really grabbed onto this, that even if we determine that this is a search, there are two bodies of law about how the government can get information, conduct searches. One is through the warrant line of cases, but the other is through the subpoena cases, compulsory process cases. And the government's theory was, if we choose to operate by subpoena, the only thing the Fourth Amendment says is that the subpoena has to be reasonable, which means seeking information relevant to an investigation, not grossly overbroad, and not grossly overburdensome to the recipient. And the court rejected that. It agreed with the government that all the previous cases about subpoenas in the Supreme Court had allowed them to be viewed under that really forgiving reasonableness standard. But the court explained that none of those previous cases had dealt with this situation where the government is seeking records from some entity in which the suspect, the target of the investigation, holds a reasonable expectation of privacy. Those other cases were about true business records in an investigation of a company, or about tax preparation records that are being created for government disclosure anyway, so they weren't private. This is just a new context, and without a warrant, there will be insufficient protection. So that was the majority. There were dissents, 4 separate dissenting opinions, kind of covering the whole range of griping about why this was going to unleash a parade of horribles. Justice Gorsuch wrote for himself. He didn't join any of the other dissents. And it really was a concurrence until the last couple of paragraphs where he got to the edge of the precipice and then stepped back and said, give me another case and I'll tell you more. But Justice Gorsuch's theory, and we had briefed this at the Supreme Court, really hoping that he would be interested in it, and in fact he really grabbed onto it. These were arguments that had been aired before, including by Judge Smith a number of years ago. Justice Gorsuch thinks that the CATS test, the reasonable expectation of privacy test, is hard to apply, is outdated, is squishy, doesn't adhere to the text of the Constitution, and should just be jettisoned. And he thinks in its place, we should look to a closer textual analysis that will let us figure out what kinds of papers and effects and houses and persons and in what situations the Fourth Amendment applies to and protects. So here's how his analysis would run. So first, what does the text of the Fourth Amendment say? Well, it protects persons, houses, papers, and effects against unreasonable searches and seizures. So the operative question for him is not, is it a search in the sense that the word search has now come under Katz and the subsequent cases to encapsulate this entire universe of legal analysis and unstated tests about expectations of privacy. He would just take search to mean like the common sense way that search might have been defined in a dictionary in 1791. The real question is a search of whose thing. So whose paper or whose effect is it? Is it the phone company's record, the phone company's digital papers, or is it Mr. Carpenter's papers, or is it shared between them? And to figure out the answer to that question, Justice Gorsuch would look to positive law, meaning statutes at the federal and state level, common law of torts, common law of property, either the kind of original, early Anglo-American common law, or updates in recent cases trying to interpret those protections in the digital age. And so the question is, does some source of positive law grant a substantial legal interest in the information, including at least some right of the target of the investigation to include, exclude, or control its use? So, for example, in this case, there happens to be a federal statute, the Telecommunications Act, that requires that cell phone service providers get affirmative, prior express consent of the customer before selling, trading, or otherwise alienating cell phone location data. Now, that statute doesn't, by its plain terms, apply to the police. It applies to basically everyone else and has a carve-out for as otherwise permitted by law, which then gets you back to the Stored Communications Act. But the argument here is that creates essentially a property right? The right to deny certain uses of the data. That should then trigger the whole mechanism of the Fourth Amendment, because now it's not just AT&T's records, it's also Mr. Carpenter's records. They might share some property rights in them, but that means he gets to complain under the Fourth Amendment when they're obtained without a warrant. So Justice Gorsuch did all that explaining, and then he got to the second to last paragraph, and he said, but I'm so sorry to tell you that these arguments were forfeited in the district court and forfeited in the Sixth Circuit, and I really wish I could give you the thrilling conclusion to my story, but that will have to wait until next time because it hasn't been well enough developed in this case. Which leads me to my first fist-pounding exhortation to you: always make property-based arguments. Even if it's your fifth line Fourth Amendment argument, way down in your alternate arguments, Justice Gorsuch has clearly signaled that he will only truly entertain this line of argumentation if it's been developed from the district court up. So preserve it, make it, even if you think it's a weird, threadbare argument, put it in there. That may be the difference between winning or losing one of these cases later on. We never know where the 5-justice majority will come from. Justice Roberts is here now, and he seems committed to these issues, but there may be some types of data that he thinks is just a bridge too far. Justice Breyer is not a tremendously reliable vote in search and seizure cases, and so it may be that Justice Gorsuch is the key fifth vote in some future case, and he doesn't want to hear about cats, he wants to hear about property, so please, please, please preserve those arguments. Okay, so some words about how to take Carpenter forward, and we'll talk more about this amongst ourselves. But the court really tried to belabor the narrow nature of the decision and had this whole list of things that the decision wasn't deciding rather. So requests for less than 7 days of cell site location information. By a quirk of the facts of this case, there were 2 requests, one for the 152-day period, one for 7 days when Mr. Carpenter was out of state and roaming on a different network. So the court said, we only have to decide here that at least 7 days is a search. If there's a lesser amount that doesn't implicate expectations of privacy, we'll deal with that later. Real-time cell site location information, tower dumps where where a crime occurred and police want a list of all the cell phones that talk to cell phone towers near there to try to find a suspect. The court said it was not disturbing application of Smith and Miller, not addressing quote-unquote conventional surveillance techniques such as security cameras, other business records that might incidentally reveal location, other collection techniques involving foreign affairs or national security. In some sense, that's the limitations of the opinion. In another sense, that's the list of things to start looking at next to figure out where we can extend this. But as we start thinking about how to extend Carpenter, I think it's useful to try to distill out, is there a test from Carpenter? That not explicitly, but there are certainly a lot of descriptors, a lot of factors. And one way to try to come up with a test is to, of course, use the language of the opinion itself. And towards the end of the section that does the CAT's reasonable expectation of privacy analysis, the court has this sentence that I had up on the screen before that identifies kind of three buckets of categories, right? So that the data had a deeply revealing nature, that it had a depth, breadth, and comprehensive reach, that there was an inescapable and automatic nature to its collection, and then there's this fourth overriding factor based on that role of the Fourth Amendment in assuring preservation of that degree of privacy that existed prior to at the time of the Fourth Amendment's framing. In other words, some scholars have talked about this as the efficiency factor, right? So this technology gives police the ability to do a thing they never would have had resources or ability to do before, and that now is of constitutional significance. And there are lots of other descriptors that I talked about: pervasiveness, retrospectivity, the time machine effect, granularity or precision of the data now, or the trend in precision going forward, the unavoidability of creation, revelation of the privacies of life, that the data is available not just for the particular suspect who police start to investigate today, but available for all or substantially all Americans, right? We all have cell phones, therefore this data exists about all of us, free for the picking unless the Fourth Amendment applies. So what are some of the other kinds of data that I think are maybe most ripe to apply Carpenter to? So just very quickly, as Megan said, contents of communications is now pretty well settled in dicta and lower court decisions. Contents of emails and text messages, but things like internet search history, browsing history that are communicative contents in some sense, but maybe not in a very technical sense, I think should be pretty ripe for protection in light of Carpenter. Information about the interior of the home from so-called Internet of Things devices, smart devices. That combines kind of the Carpenter analysis about third-party doctrine, but also the Cairo analysis about learning what's happening in your home. So even though a smart thermostat now knows when you're home and when you're not, and shares that information with a server somewhere else, that should be protected. Information about the state of the body, say heart rate data from a smartwatch that may provide or disprove an alibi in a case based on whether, there was a case a few years ago in, I think, Ohio, maybe Indiana, where police got a warrant for pacemaker data from a suspect. In an arson investigation, the suspect said he was home on the couch and police thought he was running from the scene of an arson, and so they wanted to get his heart rate data to see whether they were right or he was right. Now you don't have to go to the pacemaker in the body, you can go to Apple or Fitbit to try to get the same information. Other kinds of location data historically stored, say by Google or other companies, real-time or historical data collected by the government itself, automated license plate reader data, stingray data, others, and lots of stuff besides. In addition to these kinds of location data and third-party held data, just want to flag, and maybe we can talk about this more, that I think Carpenter is also really strong support for urging courts to reject a mechanical application of other totally unrelated Fourth Amendment doctrines to digital searches, right? So the court in Carpenter and also in Riley a couple years before very strongly explained that we can't just mechanically extend older Fourth Amendment precedents to newer kinds of digital searches. So things like consent doctrine, right? The scope of consent for a search of a phone or a computer has to be very narrowly construed, and I think there's good language suggesting that we have to evaluate that anew. Abandonment doctrine, right? Abandoned cell phone, dropped out of a pocket of someone fleeing police. Can the normal rules that something discarded by somebody and not picked up from the police station within a reasonable amount of time apply to cell phones? Surely police can't get around Riley just by saying abandonment per se applies, or abandoned DNA samples, so quote-unquote abandoned DNA found on the lip of a coffee cup by police that they say you left at Starbucks, too bad for you. The voluntariness language in Carpenter is really helpful. The border doctrine, as you heard about yesterday, plain view doctrine in computer searches, all of that, I think we are on strong footing to say you have to do a new analysis for these digital searches. And then just a couple small practice points, small but important. Again, don't forget the Gorsuch arguments. Always be Gorsuching. I think it's really important to preserve those. So at the suppression hearing, it is really helpful in setting these cases up for appeal to try to get introduced the whole range, the full set of records the government got, not just the particular subset that you want to try to suppress, right? So in the Carpenter case, for example, there were a total of 16 individual location points that placed him at the scenes of these crimes. And that's what was introduced, those like just 16 little lines of data were actually introduced at the suppression hearing. There were almost 200 pages of cell site location records, about 13,000 location points collected all told. And it was relatively harder to get the appellate courts to sort of look at the full scope of the invasion without that being in the record. We were able to kind of sneak it in through amicus briefs, but helpful for talking about why this digital data is different to have it all there. And similarly to, if you're questioning a government agent on the stand, ask about the full range of stuff they can or do collect in order to illustrate why this is just a categorically new kind of search. For those of you practicing in state courts, in states where the state constitutional search and seizure doctrine provision is not just interpreted in lockstep with the Fourth Amendment, please obviously make state constitutional arguments helpful for your clients, also helpful for the development of Fourth Amendment law. Federal courts and the Supreme Court often look to state interpretations of their own constitutions to see whether the same thing might work in the Fourth Amendment. And then finally, please, if you have these issues arising, I would love to be in touch with you. We file amicus briefs, have materials, love to just talk through how Carpenter and other cases in this area might apply.
All right. Well, it's an honor to be here, especially with my friend Nate. I will tell you that I was in the audience when he argued the case, and it was an impressive performance, especially for a rookie, first time at the Supreme Court. That is an intimidating setting. Even if you're sitting in the audience, it's intimidating. And Nate handled it just marvelously. As mentioned, about 13 years ago, as a neophyte magistrate judge who didn't know any better, I wrote an opinion on a matter, turned out to be a matter of first impression, dealing with trying to find an answer to this question of what is the legal threshold the government needs to meet in order to get cell phone tracking data. I had a very simple idea. And the simple idea was a cell phone is a tracking device. It doesn't look like one, but it functions like a tracking device. If it looks like a duck, walks like a duck, talks like a duck, it's a duck. So if the cell phone is a tracking device, now obviously at that point in time there wasn't any legal precedent on cell phones and cell phone location data, but there was precedent, Supreme Court precedent, on tracking devices. And one of the decisions was mentioned in the Supreme Court decision in Carpenter, the Knott's decision, basically providing that a beeper that's being monitored on a public highway doesn't really constitute a Fourth Amendment search. But the other bookend of that issue was the Cairo case, Cairo versus United States, which the court said, well, no, if a tracking device is monitored in a protected space and yields information about the presence of the monitor within the home or a storage area that's subject to protection under the Constitution, Fourth Amendment applies. Cairo did not decide whether a warrant was required, but the court did say indiscriminate monitoring of property withdrawn from public view would present far too serious a threat to privacy interest in the home to escape entirely some type of Fourth Amendment protection. Well, so I took this idea, cell phone is a tracking device, and applied the precedent for tracking devices and basically said, look, what the cell phone tracking information is doing is yielding information about individuals' location and about what they're doing, typically within a private space. Now, not always, but everybody, you carry your cell phones outdoors, but also inside. And so that was my idea. And so extrapolating from that, I wrote an opinion saying, Fourth Amendment arguably applies here, so I'm not going to interpret the Stored Communications Act to allow this type of collection on less than a probable cause standard. Wrote the decision. It was actually the second decision that actually came out on that issue. My good friend Jamie Ornstein, a colleague from Brooklyn, independently was working on that same issue. He beat me by about 2 months, but we both reached the same result that Fourth Amendment applies here. Now, other magistrate judges disagreed with us, and I knew, even among my colleagues in Houston, that they didn't all agree with my analysis. And so I closed the opinion with basically a plea for help. I begged the government to appeal. Ordinarily, you write decisions, you don't want appeals, but this time I wrote the opinion and I said, please, appeal this decision to the Court of Appeals so that magistrate judges who are faced with hundreds of thousands of these orders every year or applications every year will have some guidance. We'll know what the law is, because as it stood right then, and for many years afterwards, the law was whatever a magistrate judge decided it was. We could do whatever we wanted to do, which meant, you're right, it's a situation ripe for judge shopping, which is not a healthy situation. So, a plea for guidance. That was 2005. I wrote another decision in 2010, specifically on historical cell site information that got reversed by the Fifth Circuit. And actually, I think that was the first Court of Appeals to reach the issue and deal with the third-party doctrine. So today, I must admit, it's a little gratifying to finally have an answer 13 years after I asked for it from the Supreme Court. And it's especially gratifying that it turned out I was right. I will say in the intervening years, some doubts have begun to creep in. 5 separate courts of appeals had disagreed, and that's the more remarkable thing about this case. And there are a lot of people in this room, including Nate, but a lot of other folks affiliated with the EFF, ACLU, NACDL, who did a lot of work on this to get to where we are. But it's just remarkable to me that the Supreme Court would actually reach down and grant cert on an issue that all 5 circuits who had considered it had agreed upon and said, no, Fourth Amendment doesn't apply, third-party doctrine controls. So again, kudos to my good friend Nate and all of you who worked on it. The decision was surprising in many ways, and surprising to me in the path of the reasoning that was taken. I call it early in the opinion, Justice Roberts says there are a lot of different rubrics that could apply. There's not one rubric that will tell you exactly in every case whether there's a reasonable expectation of privacy under Cass. And my tag for this case is it's a story about rubrics not taken. I mean, it seemed to me the most direct path to a Fourth Amendment protection here was the Cairo case. After all, this is tracking information. It's a record of tracking information, but it's a record of information of where people have been over a period of time within their homes, other constitutionally protected spaces. That seemed to me a very direct and straightforward basis on which the court could have ruled. The court didn't even cite Cairo. It didn't even cite it. It cited Knotts, but it didn't even go down that path of the tracking precedent. Now, I have written with a colleague, my good friend Susan Freewall, Dean Freewall, acting Dean Freewall, who's professor at the University of San Francisco Law School. We co-authored a case comment in the Harvard Law Review, which I think is in the materials here, about the Carpenter case. And as we explained, and I think as Nate just explained, the court basically took a normative approach, a multi-factor approach to deciding whether or not reasonable expectation of privacy exists. And many have noted the similarity of the factor analysis that Justice Roberts applied to the analysis that Professor Freewall in her writings and her scholarship has advocated for, a multi-factor or Freewall Factor test, so to speak. And many of them, although they don't exactly use the same descriptors, but they're basically the same. If the request involves surveillance or a technique or a search that's hidden, that is continuous over time, that is indiscriminate, it's going to yield a lot of non-pertinent information, that's intrusive, all those factors go into whether or not you're going to have a reasonable expectation of privacy. And that's basically the way Justice Roberts wrote this decision. He's a wonderful writer and a great turns of phrase, great with rhetorical skills. But basically, we're left with, he didn't take the easy way out. He took a hard approach, looked at all the facets of this technology and stepped away from facile, time-worn doctrines that, like the third-party doctrine, that have come to rule and turned into easy pegs for judges to put their hat on and avoid the hard work of doing the analysis. I mean, is this really the type of does this technique impact the level of privacy that perhaps would have been expected by those who drafted our Fourth Amendment? So again, Susan's here today, so kudos to her. And again, all the others who did so much wonderful work on this case. I'll get to a little crystal ball, and we can go back and forth as to, and I'd love to hear questions from the audience as to certain applications, where we go from here. But one thing I do want to note, and this is kind of one of the points of our article that we wrote, is to note the time lag here. The gap between law and technology, unfortunately, it seems to be growing. This technology, cell phone tracking technology, is 20th century technology. It's been around for a quarter of a century. Government and law enforcement has been getting this information and using it back in the 1990s, and Congress is aware of that, and they passed some laws that referred to it and tried to give some guidance, but didn't really take the bull by the horns and actually set out a standard. But this has been going on for a long time, even before I wrote my first decision in 2005. And then judging from 2005 until 2018, that 13-year period, as Nate mentioned, these type of requests happen hundreds of thousands of times, or over 100,000 times a year. And the problem is nobody really knows how many times or how many of these searches have been authorized. He mentioned, I think, two providers in the amicus briefs that were filed with the court noted that in transparency reports filed by Verizon, I believe, and AT&T, combined in 2016 and 2015, each of those years, they had more than 120,000 requests for cell site location alerts. Now, that does not mean 120,000 searches, because each of those requests, or very frequently, very commonly, those requests encompass more than one phone. In Carpenter itself, the orders that were involved, I think there were 3 orders that encompassed something like 19 different phones. So you multiply that out, and you're looking at millions of searches that occurred, perhaps 1 million a year from 2005 to 2013. Those are all illegal searches. Those are all unconstitutional. Can we do anything about them now? No. So that's troubling to me. I mean, it seems to me that we need to do something to close this gap. Doesn't augur well for 21st century technology. How long is it going to take to get a definitive Supreme Court ruling on facial recognition technology? I hope it's not till 2040, but that's a big concern. So that gap needs to be closed. The regulatory gap between law and the new surveillance technologies. That's why I'm excited to be part of this program and perhaps help you as practitioners to help us close this gap and be alert to these issues, and so you can raise them and get courts to make rulings, and then eventually get some final guidance. At this point, I don't know. I was going to talk about my crystal ball. Nate has already mentioned some of the techniques that Carpenter will probably apply to. I think there's some low-hanging fruit out there. I think real-time CSLI is going to be the easiest to apply. I don't really see a difference between historical cell-site information and prospective cell-site information. By the time it gets to trial, it's all a record anyway. And the only difference is that real-time tracking is typically generated at the request of law enforcement, because they're not asking for records that the provider already has or is already going to keep in their ordinary course of business. They're asking for more precise location data. Now, as a matter of course, typically real-time location warrants only last 30 to 40 days, whereas the historical data theoretically goes back as long as the provider keeps it, now 4 or 5 years. But anyway, I don't think that's going to be a difficult reach. One thing, and then I'll shut up, but one point that Nate made that I think is an important one for you, because in terms of applying Carpenter, because Justice Roberts in footnote 3 especially said, okay, we're deciding whether or not a request for 7 days worth of tracking data is protected by the Fourth Amendment, and we're not deciding anything less. The interesting thing about that is, and Nate kind of alluded to it, that number is kind of picked out of thin air. Because there were 2 orders that he referred to, one for 152 days worth of data, and in response they got 127 days. Then there was a second order for the roaming data, and that was a request for 7 days of data. They only got 2 days out of that 7-day request. So I'm curious as to why Justice Roberts says the time limit is the data, the length of time requested for the data, as opposed to the amount of data actually received. And we've exchanged some emails, and Nate has some thoughts on that. So let me just toss that question to you, Nate.
Yeah. So it's very briefly, unclear why, other than that it was sort of how the case was briefed. The 7 days is what Justice Roberts focused on. But I think the justification, if you are facing this in a suppression motion, is that the only way to provide clear ex ante, before the fact, guidance to law enforcement and prosecutors and phone companies is to explain what duration of request, assuming there's some durational line between a de minimis request that doesn't tell enough about a person's life and some period of time that crosses the Fourth Amendment threshold. The only way to provide guidance is to explain what the request can get. And what comes back is relevant to what can be suppressed. It's a kind of remedial question, but when we're talking about search warrants and the proper scope of judicial authorization for searches, we're talking about the scope of the permission given to law enforcement, right? The particularity, what they're allowed to search in a house. Even if they don't search all the places that were overbroad, the warrant is still improper if it goes beyond.
But the interesting thing is that Justice Roberts did not rely on the request of time limit when he was talking about the intrusiveness and all the privacy infringing things. He focused on the amount of data points that were actually received per day on the data. So like 101 data points per day that he worked out. So he focused on the data that was accessed in terms of making his Fourth Amendment intrusion argument, but in terms of cabining the opinion, he said, okay, we're talking about 7 days worth of data. So it seems, anyway, a practice step seems to me, you could really argue that in effect, what Justice Roberts was saying was, well, 2 days of access data is sufficient to trigger the warrant requirement. As a practical matter, I don't think that issue is going to come up very much because most prosecutors, at least in my experience, are going to be asking for more than 7 days worth of data. So, but in any event, I don't think that's going to be much of a hang-up.
I also want to give all of you one more kind of hopefully helpful practice tip, even if it's not all that specific. So one thing that we've seen in a number of the cases that we've discussed throughout the conference, including Riley, and I think it's about to happen with Carpenter, is very subtle changes in the rote boilerplate language that you see in warrant applications when you start getting your discovery, right? When you start finding out what happened in your client's cases. Very minor changes to language that when you read them quickly sound like they say essentially the same thing, but the words are different, tend to signal a change in law enforcement's interpretation of what the warrant covers. So you should keep a really eagle-eye look at the warrant application language that you see in your future cases, because it may signal that your local law enforcement or the FBI or the DEA, whoever you're dealing with, has tried to change what the request is because they're trying to get away from whatever it is Riley or Carpenter would otherwise require them to get a warrant for. And we just got the signal that I think we're out of time, but the three of us will be around for a little while, so feel free to come find us. We are happy to talk to you about any of these issues. Oh, we got one question. We got time for one question.
So the question is, in Mr. Carpenter's case, the CSLI was additional to testimony. It's corroborative evidence. Are there cases I know of where CSLI is the only evidence? I don't know. I suspect, I think it would be probably rare that it is literally the only evidence, but I'm sure there are lots of cases, I haven't looked at this, but I'm sure there are lots of cases where it's a lot more thin. Here there were 7 co-defendants who gave testimony. All of them agreed on all the operative things. So the only thing available was to try to say, they have plea agreements, they're trying to please the government. I'm sure there are cases with less of that, but I don't actually know.